Hi everyone. So we're going to talk about OPDs. So just the way this is going to work is I'm going to do just a brief introduction about what we're going to be talking about, and then we're going to have presentations. I'll be introducing the presenters. Then we're going to have a Q&A session when we're all done. And you'll have your opportunity to ask questions of the presenters. We have a few other people in the audience that are very knowledgeable about OPDs, and we're going to ask them to be available to answer questions as well. So first of all, I guess the question is, what is an OPD? An OPD prohibits parking of all vehicles between 2 a.m. And either 5 a.m. or 6 a.m. It depends on where the district is located, unless a permit is displayed. So in Venice, posting of a permit-only parking would be on a block-by-block basis. So people opt in to display the permits. Arturo Pina is going to be talking and doing a little presentation on how permits are acquired. He'll also be talking about the oversized vehicle ordinance and how those signs can be posted and how the two OPDs and OVOs can be used. He'll also talk about how you get a permit once the signs are posted. Now, the situation that we have right now is the city can't post OPDs in the coastal zone without a permit from the California Coastal Commission. California Coastal Commission enforces the state laws regarding open access to the coast. The city requested a permit in 2009, and that permit was denied. The permit was modified and resubmitted in 2010, and it was denied again. So what we have before us and what we're going to be talking about is a new permit application. So we've got it's not a new permit application, pardon me, it's a modified application once again. And that's been submitted to the California Coastal Commission, and they will be reviewing that and deciding on it in June. So we're going to hear tonight about the modified application for our DOTs from Tamara Martin. Tamara is with the Department of Transportation. After the city's OPD application was denied, the Coastal Commission and the city were sued by Venice Stakeholders Association to require that the OPD's permits be granted. This city later joined that suit against the Coastal Commission, and Jane Usher is here from the City Attorney's Office, and she'll talk about the status of that lawsuit. Finally, the California Coastal Commission has jurisdiction, it's joint jurisdiction between the city and the California Coastal Commission in the coastal zone. And because of that, the California Coastal Act, which regulates the initial coastal access and sets up the Coastal Commission, we thought it would be a good thing for you to hear a little bit about that. We invited the representatives of California Coastal Commission staff to be with us tonight to present on that subject. They are not here. Fortunately, we have Sarah Wan in the office, in the audience. And Sarah is a former California Coastal Commission director or commissioner, and so she will talk a little bit about the California Coastal Act. So, as I said before, we expect the presentations to take about 20 minutes or less. We'll have the question and answer session, 40 minutes, and we hope to be done in an hour. When we get to the questions, I think I mentioned before, we won't be using speaker cards. Don't know what questions you're going to ask, so we're going to ask you to raise your hands. I'll call on you, And please, it's questions only at this session. No opinions. That includes the board as well. Just questions at this time. Next month, if there is any kind of resolution or motion to either approve or disapprove of the settlement, we'll be talking about that next month, and then it'll be appropriate to hear your opinions about that. So we're going to start off. I'm going to ask the presenters to come up. So Tamara and Jane and Arturo, we've got some seats reserved for you right up here. Yeah. Thank you. And Tamara, if you could lead off with what we can expect to be coming our way.
We were asked to come back and present since last appearance. We got to be later and later. So we brought back the PowerPoint that was here in January, kind of discussing the future of parking in Venice area and the effect of the overnight parking districts that have been requested, and the current state of the negotiations on the mitigations and discussions of modifications to the coastal development permits. And this is what's up here behind me. And we also have, for your reference, other copies of the maps around the room that are in the PowerPoint, since they will be easier to see. Please go ahead and advance. All right. Is there legal authority to actually have preferential parking? The answer to that one is yes. There were cases brought before the U.S. Supreme Court that do allow for a preferential parking scheme to be implemented. What you are looking at in Venice and what has been applied for is an overnight parking district to restrict parking between 2 a.m. and at a maximum 6 a.m. In earlier mitigation discussions, there had been talk of limiting Venice to a 2 to 5 a.m. restriction to allow for more and improved access to the beach. Currently, this action was brought in court after denial, as Mr. Saltzberg said, of the coastal development permits. Could we please advance to the next slide? Okay, this is the one I was discussing about the constitutionality of preferential parking districts. It has been established long ago in 1977 that such a district would be acceptable and permissible. Can we go ahead and advance? This is kind of a basic background of what's happened in Los Angeles in the LAMC, or Los Angeles Municipal Code, to allow for, which ordinances allow for both preferential parking, which we've had on the books since 1979, and overnight parking, which we started, ordinance was approved and adopted in 2005. We also, as you know, have oversized parking, which restricts certain size vehicles, and that's also a 2 to 6 a.m. restriction. Please go ahead. Okay. This is a history of what's happened with the overnight parking districts in Venice. In 2006, they were requested and went through an establishment process through the city. They went through the Public Works Board as well as the City Council, and the coastal development permit was requested in 2009. In June of 2009, there was a hearing in, I believe, Marina del Rey, wherein the commissioners denied the request for the overnight parking districts. As a result, there were mitigation efforts discussed, and those included making additional parking available, and there were additional several lots opened or going to be opened at night, and to clear the lots so that they would be able to be utilized for beachgoers. In 2010, the commissioners again denied the request for the overnight parking districts. Now, the Venice stakeholders did file suit in August of 2010, and the case has been ongoing since. It is currently, I guess, awaiting the next hearing to find out whether we can actually get the matter through the Coastal Commission. And the next hearing on this is scheduled in June. There have been ongoing discussions as to what may be acceptable to the commissioners, and unfortunately, we don't have anyone here from the Coastal Commission tonight, but the discussions have been ongoing with the staff. Please advance the slide. As most of you are aware, if you've driven through Venice, there are a number of overnight or oversized parking signs now on many blocks in the district. It's a very large district, and the way the boundaries were arrived at was there were originally several overnight parking districts requested, and those were combined into 2 different districts. There were 4 together, and then one fairly far from the core group. And you'll see those back on the back wall. Each of those districts is a different color, and you'll see where they were joined up with the outline. The other things that have been done in mitigation in this area include the Vehicles to Homes program by Councilmember Rosendahl, who spearheaded that effort to get people moving from vehicles into actually homes and to help them out and get them integrated back into society. Now, if you'll please advance the slide. Okay, this is the discussion that we were having about combining those districts. That is still on the table for the next round of mitigation efforts. Okay, we're still going to have one large district and a small district. The one large district will incorporate or fuse together 4 separate districts so that everyone will have a better opportunity to find parking. That's our goal. Okay. Originally, there was a discussion of having blocks attempt to use the oversized parking restriction for a 6-month period before they could apply for an overnight parking district. At this point, more than 110 streets have been posted with these oversized signs, so we are asking that that no longer be a requirement. Here's the actual slide of the maps on the back wall, and if you could please advance. Now, in the new proposed settlement, we are talking about the off-street parking being supplied by these lots. There was also a parking lot 740, which had 51 spaces, which we are asking to be eliminated from the next mitigation discussions. But we are talking about 357 spaces being open for public use. Please advance. Okay. This is a map showing where the current oversized signs are posted. Please advance. And there's going to be an increase of 351 on-street spaces with the next mitigation offer. We will also be excluding some commercial areas, and they're listed here. They will not be getting signs. I think they were asking for all questions to be held. I'm happy to answer it, but please make a note of it for you so that you remember to ask. Part of what they are talking about in the mitigation efforts is some additional items. One would be bike lanes, bike sharing. There is also the possibility of other mitigation efforts. Okay, as they say here, these are the streets that we'd be installing what are called sharrows, the shared lane markings. You may have seen them other places around town. And then there would be the bike lanes on those 5 streets. All right. As you see, this goes into what's going to be excluded or included in the settlement, okay? We're going to start by making 72 spaces per year available. And that'll take some time to implement, but it'll be worth it, we hope, in the end. And what we are talking about is that any timelines will begin from the installation of the first signs. Okay, so if there's a time requirement that we have to come back or do any other work, that we start from that date of first installation. Okay, now there has been a closed session meeting since we were last here, and we are going to be on the agenda, our understanding is in June, for discussion on this mitigation effort discussion, okay? If the commissioners do accept the mitigations, then it will move back to the city for approvals. Please. Now, there's been concern over whether overnight parking districts would preclude one from having preferential parking districts. And the answer is probably not, okay? So since we did get a number of questions as to whether, and input that there are residents who believe that preferential parking would be a good tool in Venice, we did include these slides. It does not mean that there will be preferential parking in Venice. It also is a subject for discussion at the Coastal Commission in June. The decision that we're asking for is an advisory one. Basically, we're going to be seeking input as to whether the guidelines that we're proposing, and they'll be listed on the next slide, would be ones that the Coastal Commission would consider. Okay? Please advance. Okay, we're to... Sure, but again, would you please write your question down and bring it up later? What happens here is that you've got to have, this area will have to have a parking study. There will have to be a significant non-resident impact shown. And we've got to have petitions from at least 6 streets. 4 of those will have to pass a parking study. We will have to, under the current rules, prepare a preliminary report, go to a public hearing. There will be a hearing officer's report and a report to the city council. Okay? There will also be coastal development permit, and then things will be presented as well to the Coastal Commission. Okay? We would have limitations as to where there could be signs, what sort of restrictions would be required or be able to be requested, and those would vary as to whether, you know, how close to the coast one got. We would not be able to use no parking signs. There would always be some time allowed for public use. Okay? Please advance. Again, there would be these mitigation measures offered to the Coastal Commission, and again, they will be making a decision, it is our understanding, in June as to whether any of these would be acceptable. Okay? Please go ahead. Okay.
Thank you very much. And if you have questions regarding the presentation, please bring them up after we're done with the rest of the presentations. Thank you very much, Tamara. And Arturo, if you could say a few words about how you get an OPD, how you get an OVO, how you get a permit if you got an OPD.
Good evening, everyone. Good to see you all. Thanks for coming out. Arturo Pina, Office of Councilmember Bill Rosendahl. I don't want to make the assumption that everyone's familiar with the Oversized Vehicle Ordinance process, but it's a very simple process. While it was very excruciating to get to that point for us to be able to implement oversized vehicle ordinances, it has been a useful tool for some of our streets. It is a petition process, block by block. We ask that residents get signatures from the 2/3 of the folks on the particular block. Once we receive those petitions, we actually phone the individuals to clarify that they knew what they were signing, because I know sometimes when you get bothered at home, you're just signing something, or maybe you don't even sign it, or maybe you didn't hear about it. So we take the time, call up each individual, and that's our verification process. Once we do that verification process, then we pass it over to our Department of Transportation engineers, who then actually visit the blocks to make sure it all makes sense, and then work orders are submitted. As far as the overnight parking district system and or program that will be implemented, that's something that's going to be visited by the incoming council member, and that council member will be able to work out the specifics, the administrative specifics, with Department of Transportation. I'm not sure if there was anything else I should add.
OVOs?
Isn't that what I explained? Oversized vehicles, that was the first one. Yeah.
Okay. All right. And then other additional questions
I'll be here.
Coming later.
Thank you.
Jane Usher is going to explain the current status of the lawsuit, and thank you, Jane.
Thank you so much, Jane Usher, City Attorney's Office. So I have Marc Ryovac here of the VENICE stakeholders, and David Ewing reminded me that you saw a slide that suggested that a lawsuit was filed in 2010. Marc, that's wrong. Very good. We're on the same page. So here is, my bad, I should have caught it, sorry. Here's the correction. You'll remember that the city went before the Coastal Commission in the summer of 2009 with the first application. You might also remember that the staff of the commission was in support of the application, but the commissioners themselves turned it down. That situation always presents a head-scratching conundrum for the party who received the denial, because they always wonder whether the record, the documents, the materials, the request, did the record support a denial, or was it improper of the commissioners to turn the city down? So that's the nature of the lawsuit, and it was filed shortly after the Coastal Commission's denial in 2009, and it asked that legal question. Did the record support the action taken by the commissioners? Both the city and the Coastal Commission were sued, and that caused the city to think through, as we must, well, what other legal questions might be raised? We added another legal question to the table, and may I just say that these legal questions are pending. The intention here is never to go to trial and never answer the questions. They're just the ones we must raise in order to put our oar in the water now that we've been sued. So here was the legal question that the city added to the mix. Rather than joining the lawsuit because the city was already a defendant, we'd been sued, we added this legal question. Does the Coastal Commission have jurisdiction over these parking permits? Is it within their wheelhouse? Here would be the pro and con. I'll give you both sides because lawyers are very adept at giving both sides. The city's side of it would be, well, if you read the Coastal Act, it talks about the Coastal Commission having jurisdiction over development, and it goes on to define development. Lots and lots of sentences are in that definition, but at the end of reading that definition, you would likely conclude that we're talking about building or installing a structure. A building, a structure, not a sign. So there's the city's argument. The issuance of parking permits and the installation of parking signs aren't within the commission's jurisdiction. And Marc, I heard you to say that maybe there's no one here from the commission, but regardless, I'll say their side, just so that you've got the full blend of the argument. The Coastal Commission would say their jurisdiction is much more extensive, and that interpretation of development is too narrow. It's too narrow. And they would say, well, for sure we have jurisdiction. Why do I tell you this? I tell you this because I think there's been tremendous misinformation and also curiosity about the lawsuit. But I think the most important takeaways are these. The lawsuit, it's a necessity. When you're sued, as we were, you have to, at that time, raise all of your legal arguments or you have waived them. So there's takeaway number one. I hope whenever you hire a lawyer, they do the same for you. They raise all the issues. They put the oar in the water. The second important takeaway is our intention in concert with the Coastal Commission, at least their staff, and the judge, who's been incredibly accommodating to this matter. The intention is we save these legal questions and we sort of put them over here and do nothing with them pending the Coastal Commission acting in June on the revised application. And the idea would be if the revised application is approved, we will all simply march back to the judge and say the matter's resolved. So there you've got it. That's what everybody hopes will happen. And, you know, I simply want to thank the council office and the Department of Transportation because they have not only taken out their pens and pencils the first time, but Marc, they've gone back to the drawing board 3 times in an effort to bring forward the best possible application from the vantage point of the Venice community. So there we are.
Thank you, Jane.
You're welcome.
So the fourth person that we're going to hear from is Sarah Wan. Sarah is a former Coastal Commission commissioner. And as I said, we had asked the Coastal Commission to actually present to us so they could give us their official opinions, but they aren't here. So Sarah can't speak for the current Coastal Commission or for the Coastal Commission staff, but she can describe the Coastal Act and the Coastal Commission's jurisdiction, and I expect that we'll have questions for her later. Thank you, Sarah.
Let me just set a little bit of a background and a framework for all of this. When the people of California passed Proposition 20, which is what created eventually led to the creation of the Coastal Act and the Coastal Commission, they made it clear that the coastal zone was to be treated differently than the rest of the state. And so, you know, I hear, for example, comments about, or statements up there about parking districts in the rest of the city. It has nothing to do with parking districts within the coastal zone. The coastal zone is different. It's treated differently. It's treated differently throughout the entire state because the people of this state made it clear they wanted it to be treated differently. The Coastal Act and the Coastal Commission is constitutional, and it is the Coastal Act, the Coastal Commission, that has the final jurisdiction over parking restrictions within the coastal zone. Why is that the case? Because one of the principal reasons that the Coastal Act was passed was to protect public access to the beach. Public access is a cornerstone of the Coastal Act. And while you live in the coastal zone, it's the rest of the state that doesn't live in the coastal zone that needs to be able to get to the coast and that drives to the coast that needs parking in order to be able to access the coast. So parking is an integral part of public parking, that is an integral part and an essential part of public access to the beach, and something that the Commission takes very seriously. The Commission has dealt with many parking districts. It's denied some and approved others. Wherever it thinks that the preferential parking districts, and I don't know what you want to call them, overnight parking districts, those are still a form of preferential parking. Okay, wherever it thinks it does not adversely affect public parking. For example, a lot of them have been approved in Santa Monica, but Santa Monica has huge public parking lots, and it has shuttle systems to enable people to use those public parking lots. So wherever the Commission believes that it won't affect public parking, it will in fact approve them. I do have to take a little bit of exception. I'm not an attorney, but I do have a lot of experience in this area. Something that has gone to court, and that is the definition of development. And development is more than what you dig with a spade or what you put up in construction. Development is also considered a change in the density or intensity of use. And public parking is a change in the density and intensity of use. So the question of the Commission's jurisdiction is pretty important here, because it's one of the things that has been challenged. And for this community, by the way, the Coastal Act, while you may not care about public access to the beach, I think you do care about the Commission and the Coastal Commission and the Coastal Act and the Coastal Commission's jurisdiction, because it's the Coastal Commission and the Coastal Act that really protects community character. You think about what happens in many areas. Venice is a special community, and it's the Coastal Act that's been protecting your community character and preventing, or at least slowing down the process of mansionization. A couple of other things I'd like to talk about. What is the Commission going to look for? Frankly, it is going to look to see whether any of these districts, and I'm talking about the Commission, not the staff. The staff and commissioners are not one and the same. As you can see, the staff, as was said, approved this the very first time. They thought it was okay, and the Commission said no. Then the staff approved it, and the lawyers came with a settlement and came back to court, to the Commission, and the commissioners again said no. So I don't think you should think it's necessarily a done deal, because you don't know what the commissioners, and I don't know what the commissioners are going to say, depending on what they hear, but I know they're going to be looking to see that whatever you put in does not adversely affect the public's ability to access the coast. And that means a number of things. It means that if you're promising bike lanes, or you're promising public access, or or ride sharing, and I don't remember all of the stuff because I didn't do an analysis of this. If you're promising parking lots, all of those programs need to be put in place, not promised, but actually put in place. Because a promise from a city that they will do something doesn't necessarily happen, and the Commission has a lot of experience with that. So they're going to be looking to see about that. They're going to look to see, for example, what happens when you have an overnight parking district where the public can't park there until 5 o'clock in the morning, and then it opens up at 5 o'clock in the morning, but it doesn't actually open up at 5 o'clock in the morning because the residents don't need to leave at 5 o'clock in the morning. So in essence, that means that area is probably, particularly in an area like this where parking is at very much a premium, that it's going to be difficult for members of the public to obtain parking. The other thing that I heard was something about the preferential, the PPDs, not the OPDs, being discussed or at the June meeting, unless it's on the agenda, the commission can't take action on the PPDs. It's not part of the settlement as I understand it. It's something that you're thinking of doing in the future, and you may find that it's highly inappropriate because you're not going to have a staff analysis or a staff report of those PPDs. And even if you were to get a straw vote, I caution you that it's not only not binding, it may have no meaning whatsoever. The next time it comes to the commission, you may have different commissioners sitting at the dais, and you will have a staff analysis and a report on what those PPDs mean. So I would caution you, if you do go down that path, to look at it very carefully and skeptically, because you may even get a vote that says, yeah, we'll look at that, and it's not going to mean anything. Let me tell you, I have a lot of experience in that.
Thank you very much, sir.